Another letter from her lawyer, another motion filed, another court date you have to take time off work for, another invoice from your solicitor, another week where you can't think about anything else because you're preparing documents, gathering evidence, trying to respond to claims that have no merit but still require a response. You thought leaving would end the abuse. Instead, it moved. The abuse now wears a suit. It speaks in legal language. It arrives in formal correspondence. And it never ever stops. Every time you think it's finally over, there's another application, another allegation, another reason you have to go back to court. That's what enlisting legal proxies looks like as an abuse tactic. The court has become another tool in her belt, another space where she directs the action while you struggle to respond. And if you've ever felt like the legal system has been weaponized against you, like the process itself is a punishment, this episode may help you understand exactly what's happening. In today's episode of the Blueprint of Family Violence Against Men, we're going to break down what enlisting legal proxies means. Then we'll walk through 5 specific ways an abuser may weaponize the legal system, from vexatious litigation to procedural harassment. Now, for clarity, I do not provide legal advice. I'm not a lawyer, and nothing in this video should be taken as legal guidance for your specific situation. But I will end this episode on what you can do from a non-legal perspective if you suspect this tactic is happening to you today. For those of you who are new here, this is Stan again, a lived experience platform for male victims of family violence. Abuse is not limited to one gender, but this channel focuses on the male perspective because it is so often dismissed or misunderstood. I also need your help to make this channel grow. So if this content helps you, please like, subscribe, and add the words "Stan again" into the chat. Those 2 words don't just tell the algorithm gods that supporting male victims of family violence is important, but it also may help a victim realize that they are not alone. Let's now start with the definition. Enlisting legal proxies involves weaponizing the legal system, courts, lawyers, and legal processes to continue abuse through institutional channels. This is not legitimate use of legal remedies. This is the exploitation of legal mechanisms to harass, deplete, punish, and control the victim. The court becomes another arena of control, another space where she directs the action while you struggle to respond. The mechanism exploits the adversarial structure of legal proceedings and the resource demands they create. Every motion requires response. Every response requires time, money, and emotional energy. An abuser with superior financial position or willingness to accrue debt can exhaust a victim who cannot match her spending. She doesn't need to win in court. She needs to make continued resistance impossible. The process becomes attrition warfare, not about legal outcomes, but about depleting your capacity to fight. This pattern is recognized by multiple names in the research: paper abuse, litigation abuse, legal abuse, coercive legal tactics, vexatious litigation, judicial terrorism. Whatever you call it, the mechanism is the same. Your abuser uses the legal system to maintain contact, exert control, cause financial damage, and punish you for leaving them. The court becomes the new relationship, the new site of control, the new mechanism through which she can reach into your life. There is data that suggests that more vexatious litigations are identified in family courts than any other Australian jurisdictions. This is not coincidence. Unlike other jurisdictions, family law provides ongoing access to a forum where an abuser can file multiple applications, make numerous allegations, demand responses, and force the other party to engage indefinitely. Unlike property division, for example, which ends once the property is divided, custody arrangements continue until the children reach adulthood. Each schedule change, each parenting decision, each transition becomes a potential legal battleground. Legal proxy abuse operates against a backdrop of structural disadvantage. Many men feel the family courts assume maternal fitness and paternal deficiency. Protective order systems also require low evidentiary standards, meaning allegations trigger intervention before any finding is made. An abuser in that system does not need to prove anything up front. She needs only to allege, and the system responds as designed. The harm here operates across two dimensions. First is harm to self and parenting. Your relationship with your children is disrupted, your parenting is scrutinized, your access is restricted, your character is attacked in formal proceedings that create permanent records. Second is harm to finances. Every legal response costs money, and if she can drain your resources through litigation, you have less capacity to fight what matters. Both dimensions work together. The financial pressure makes you more likely to concede on parenting issues just to end the bleeding. Legal proxy abuse takes different forms depending on which mechanisms she exploits. Let's now walk through 5 specific ways the legal system may get weaponized. We'll start with vexatious litigation. Vexatious litigation is the filing of repeated, meritless, or procedurally improper legal actions designed to harass a victim rather than to seek legitimate remedy. The tactic works through attrition. Each filing requires response. Each response drains your resources. She may not expect to win. She expects to exhaust you until you can no longer fight. The mechanism exploits the court's reluctance to restrict access to justice. Courts have mechanisms to address vexatious litigation, but these are rarely deployed in family law contexts. Judges are hesitant to prevent a parent from bringing matters before the court, even when the pattern of filing suggests abuse rather than legitimate concern. The system is designed to remain open, and that openness becomes a vulnerability in the hands of an abusive partner. She may file repeated motions on minor or manufactured issues, refuse to settle or negotiate in good faith, appeal decisions that went against her regardless of merit, relitigate matters that have already been decided. Each action forces you back into the system, back into preparation mode, back into spending money, back into spending time you don't have on lawyers responding to claims that shouldn't require a response. The second form is protective order abuse. Protective order abuse involves seeking intervention orders, restraining orders, or other protective mechanisms based on false allegations that don't meet the legal threshold, or that deliberately mischaracterize normal contact as harassment or threat. These orders are designed to be obtainable quickly and lower evidentiary thresholds than criminal proceedings. This accessibility, intended to protect genuine victims from imminent harm, becomes vulnerability when weaponized by an abusive partner. Your abuser presents as frightened, the court errs on the side of protection. You're removed from your home, restricted from your children, and documented as someone a court deemed dangerous enough to require protection from before any fact finding has occurred. The order itself becomes evidence in subsequent proceedings. You're not starting from neutral, you're starting from documented concern. She may obtain orders during your absence so that you cannot respond, or use order violations to create criminal liability for minor contact, like responding to a text about the children. Or your abuser may leverage orders to gain advantage in custody or property proceedings. The protective order system, which is designed to save lives, becomes a tool for control when in the hands of a manipulator. The third form is custody weaponization. Custody weaponization involves using child custody proceedings not to determine the children's best interests, but to punish, control, and exhaust you. The tactic exploits the ongoing nature of parenting arrangements. Unlike property division, which ends, custody arrangements continue until children reach adulthood. Each schedule change, each parenting decision, each transition becomes a potential battleground that she can reopen at will. The mechanism exploits the family court's operating principle that children benefit from relationships with both parents. This principle creates a vulnerability in the eyes of an abuser. An abuser who can manufacture conflict, raise concerns, and create the appearance of dysfunction can trigger judicial intervention that restricts your access. Paradoxically, courts may reward the parent who creates conflict by limiting the other parent's involvement, misreading manufactured dysfunction as evidence that contact should be reduced. Your abuser creates the chaos, then offers herself as the stable alternative. She may seek full custody despite a history of shared parenting, file modification requests whenever circumstances change, create conflicts around exchanges and schedules and parenting decisions, use children's activities to restrict or interfere with your time, or she might make educational or medical decisions unilaterally to provoke litigation action. Or she may even refuse to co parent effectively, then blame the resulting conflict on you. The children have now become instruments of ongoing control, and your relationship with them is mediated through her manipulation of the court. The fourth form is financial litigation abuse. Financial litigation abuse involves weaponizing the financial instruments of separation, such as support calculations, asset division, disclosure requirements, and enforcement proceedings. The tactic attacks your economic foundation directly. She manipulates the mechanisms that determine how money flows after separation, using them to impoverish, punish, and control you. The mechanism exploits the complexity of marital finances and the difficulty of disproving vague claims. She may allege you're hiding income, demand support calculations based on earning capacity rather than actual earnings, or claim undisclosed assets without evidence. The allegation triggers an investigation, forensic accounting, and disclosure requirements. You must prove negatives. You must account for every dollar. The burden falls on you to demonstrate that what she's alleging is not true. Your abuser may seek excessive or unreasonable support, knowing you'll have to fight it. She may refuse to provide her own financial disclosure while demanding exhaustive disclosure from you. She may dispute settled asset division, reopening matters that should be closed. Or your abuser may seek emergency orders to freeze your accounts or restrict your access to funds, leaving you unable to pay rent or legal fees while the matter is resolved. She also may even use enforcement proceedings punitively, pursuing technicalities rather than legitimate non-compliance. The financial architecture of separation becomes another mechanism of control, another way to reach into your life and squeeze. The last form is procedural harassment. Procedural harassment involves exploiting legal procedures like discovery, subpoenas, scheduling, compliance requirements to create burden independent of the case's merit. The tactic makes the process itself punishing. Every court date is a day off work. Every document requires a response. Every motion requires review. She can impose costs simply by making the process as procedurally complex, slow, and demanding as possible. The mechanism here exploits the invisibility of procedural burden to courts focused on substantive outcomes. Here, the judge often only sees the legal issue to be decided. They don't see the hours spent preparing documents, the work missed for hearings, the emotional toll of constant legal engagement. The harassment is felt acutely by you, but typically invisible to the court that could stop it. You drown in legal process while she controls the flood. Your abuser may schedule hearings when she knows you have work conflicts, demand excessive or irrelevant documentation, subpoena witnesses unnecessarily, or she may refuse to agree to routine procedural matters. She may miss deadlines, then blame you for enforcement proceedings. Your abuser may use continuances or delays to extend proceedings indefinitely. The substance of the case may be really straightforward. The process, however, around it is designed to break you. Let's now move into tools and protection. As I said at the beginning, I wanted to be clear, I do not provide legal advice. I am a trauma coach. I am not a lawyer, and nothing in this video should be taken as legal guidance for your specific situation. What I can do is help you understand the pattern you're facing and point you towards the kind of support that might actually help. The first and most important tool is to find a family lawyer who understands coercive control. Not all lawyers recognize litigation abuse as abuse. Many see high conflict family law cases as two difficult people who just can't get along. They don't see the patterns, They don't see that one party is using the system as a weapon while the other party is desperately trying to survive. You need legal representation that understands this is a pattern, not just a difficult divorce. Seek out a lawyer who understands coercive control and will recognize the attrition strategy. They'll help you distinguish between what battles matter and what battlegrounds are designed purely to drain you. A lawyer who understands coercive control will help you understand that your goal is not to win every motion, but to survive the war. They'll know how to document patterns for potential vexatious litigation applications, and they'll treat you as a victim of ongoing abuse, not as a participant in mutual conflict. When you find that lawyer, listen to them. Trust their advice. They'll understand the legal landscapes in ways you do not, and they can see strategic options you might miss. Your instinct may be to fight every allegation, respond to every provocation, defend yourself against every turn. Sometimes the right legal strategy is different. Let your lawyer guide you. The second tool is to document the pattern, not just the individual incidents. Courts see individual motions, they don't see the aggregate. A single application might look reasonable in isolation. 30 applications in 2 years looks like something else entirely. So keep records that show the pattern, the number of filings, timing, outcomes, costs incurred. This documentation can help your lawyer demonstrate to the court what's happening is not just normal legal process. The third tool is to protect your financial capacity to respond. Litigation abuse is economic warfare. Every dollar you spend on legal fees is a dollar she's extracted from you. Work with your lawyer to identify which battles matter and which are just designed purely to drain you. Strategic non engagement, where legally possible, can preserve resources for the fights that genuinely count. This is not about giving up, it's about recognizing that you're in a marathon, not a sprint, and you need to pace yourself accordingly. Some jurisdictions have mechanisms for cost recovery when litigation is found to be vexatious or without merit. Some have specific abuse litigation laws that can restrict an abuser's ability to file further proceedings without the court's permission. Your lawyer can advise here whether any of these apply to you. Enlisting legal proxies is one of the most emotionally and financially exhausting forms of post separation abuse. It's relentless, it's expensive, it's draining, and it exploits a system that was not designed to recognize what's happening. The courts see a family law matter. You are living inside a campaign of control that simply changed venue when you left the relationship. The process is the punishment. Your abuser knows that. Every filing, every motion, every hearing is a reminder that she can still reach you, still cost you money, still consume your time and energy, still make your life revolve around her. The abuse didn't end when you left. It moved to a forum where it's harder to name and harder to stop. But you are not powerless. The right legal representation makes a difference. Understanding the pattern makes a difference. Documenting what's happening also makes a difference. And knowing that this is a recognized form of abuse, that you're not imagining it, that other people have faced this and survived it, that also makes a difference. This is Stand Again, lived experience platform for male survivors of family violence. Please like, comment, and subscribe. Your voice might just help another man find his. If you're looking for one on one support, you can book coaching with a member of the Stand Again team. Simply visit standagain.com.au, where you will also find grounded information on surviving and recovering from family violence as a man. As always, remember that no matter how many times you've been knocked down, you can stand again.